Senator John Kennedy doesn't mince words, and in this must-see judiciary exchange, he delivers a brutal reality check on legal ethics, judicial legitimacy, and constitutional principles. One moment you're laughing, the next, you're learning.
Mr. Wrights, I introduced Senator Cruz to some of his supporters one time. I was asked about him, and I said, "No, let me tell you about Senator Cruz. He's brilliant, but so was the Unabomber. You've got to watch him like a hawk." Was that a fair description? You don't have to answer that. Is it true that after a Scot, Senator Cruz can burp the alphabet backwards? You don't have to answer that either. Let me say something serious for a second, and then I'll have one or two questions. You're all adults. You're all officers of the court. So I'm going to give you some advice. I may be wrong, but I doubt it. Don't ever take the position that you're not going to follow the order of a federal court. Ever. Now, you can disagree with it. Within the bounds of legal ethics, you can criticize it. You can appeal it. Or you can resign. For 4 years, I have watched people in this town, not everybody, but many, try to undermine the legitimacy of the federal judiciary. And it triggered each and every time my gag reflex. I've watched them try to pack the Supreme Court. I have watched an esteemed member of this body on the steps of the Supreme Court threaten Justices Gorsuch and Justice Kavanaugh. I've seen that. I've seen this body, some in good faith, but some in bad faith, try to impose an unconstitutional, violative of the separation of powers doctrine, ethics code on the Supreme Court, just to try to undermine their legitimacy. Now, all our judiciary has, an equal branch of government has its legitimacy. It doesn't have an army. Don't ever say you're not going to follow the order of a court. You may not agree with it, but that's my advice, and I think you ought to take it. Mr. Sauer, I'm glad to see that Hawley took you to a Cracker Barrel for lunch.
Yes, Senator, if you're familiar with the area, it's the one near Columbia, Missouri, about halfway through Missouri on I-70.
I've always thought of Hawley as more of a Whole Foods type guy.
I can only say that his description of it was accurate. It was chicken fried steak.
I'm glad to see that his taste is getting better. Tell me, Mr. Sauer, give me an example of an instance where a legislative body could pass a statute discriminating on the basis of race, which of course is a suspect classification, that could pass the strict scrutiny test.
I can't think of a hypothetical as I sit here. However, I am aware that there is a line of cases holding that.
I am too, but is there any way that a legislative body can pass legislation classifying people on the basis of race that passes strict scrutiny?
I can't imagine a scenario as I sit here, Senator.
How does the doctrine of equal protection apply to the federal government? I know the 14th Amendment says that the states can't deny our people equal protection of the law, but I don't see anything in the Constitution about the federal government in equal protection. It's not in the Fifth Amendment. I'm not suggesting we shouldn't, but how does it apply?
Senator, I believe there's a Supreme Court decision from the late 1940s or early 1950s that essentially incorporated the doctrine of equal protection. People say reverse incorporated the doctrine of equal protection through the Due Process Clause of the Fifth Amendment.
You agree with the substantive due process model?
I have criticized that doctrine in many of the legal briefs that I've filed that I've disclosed to the committee.
Well, without it, how would we have equal protection of the laws applied to the federal government?
As I sit here today, I don't dispute the holding of what the Supreme Court held about 60, 70 years ago, and I accept that as binding law.
You just think they got the methodology wrong?
Well, you asked about the substantive due process doctrine. The doctrine of reverse incorporation is different than that. And as I sit here today, I'm not prepared to say whether they got it right or got it wrong. I'd have to read the opinion again. It is long settled in binding law, in my understanding, though.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy. And in light of your initial line of questioning, I ask unanimous consent that at subsequent hearings, Senator Kennedy be bound and gagged. I'll withdraw that request and recognize Senator Whitehouse.
This Judiciary Committee moment is vintage Kennedy wit, wisdom, and warning shots all wrapped into one. He opens with sharp humor, but pivots quickly to deliver a pointed message: do not undermine the legitimacy of the federal judiciary. His advice to judicial nominees was clear and blunt: never take the position that you won't follow a federal court order. Kennedy's concern? That political movements from court-packing proposals to ethics attacks are eroding the public's trust in the judicial branch. He goes on to challenge nominee Sauer with tough questions on strict scrutiny and racial classifications, exposing just how hard it is to justify any law that treats citizens differently based on race. Then comes a deeper dive. How does the Equal Protection Clause apply to the federal government? It's a question that reveals the tension between legal precedent and constitutional interpretation, especially around the controversial doctrine of substantive due process. This was no ordinary Q&A. It was Kennedy at his best, mixing Southern charm with constitutional firepower to draw out where these legal minds truly stand. If you believe in holding Washington accountable with clarity and a little bite-like, comment with your take and subscribe. This is America Progress, and we break it down without the spin.